going to go ahead and get started. Welcome everyone to the National Veterans Legal Services Program discussion on class actions in veterans law. I'm Perry Cooper. I'm senior legal reporter at Bloomberg Law. I used to cover class actions, and since January I've been covering the Federal Circuit, where all veterans court cases are appealed. So this is an emerging area I've been watching for a while now, and it's been interesting to follow. We've got a really great group of panelists that come at the issue from every angle, so I think it's going to be a great discussion. I'll start with a brief introduction of our panelists. Their full bios should be in the materials you got, so I don't want to take up too much time going through their extensive resumes. But we'll start with Judge Michael Allen. He is on the U.S. Court of Appeals for Veterans Claims, which I will shorten to Vet Court, so Veterans Court, so it's easier to get out. And Judge Allen has been on the court since 2017. Next up is Mary Flynn, who's Chief Counsel of the Veterans Litigation Group at the VA. She's been with the VA since 1992 and is a 30-year Navy veteran. Bart Stickman is co-founder and executive director of the National Veterans Legal Services Program and our host today. And Adam Zimmerman is a professor at Loyola Law School in Los Angeles, who specializes in class actions and administrative law. I'm hoping to keep this a lively discussion among our panelists, so I'm hoping that they will jump in. I also want the audience to be engaged, so we have the questions you sent in ahead of time, but if you want to throw questions into the question and answer widget as we go, I'll keep an eye on those and throw them in as they're relevant, and we'll save some more time for questions at the end. So I want to start with Bart. The Veterans Court said for years that it didn't have authority to handle veterans claims as on a class action basis. And that changed with the Federal Circuit's decision in 2017 in Monk versus Shulkin. So can you give us the background of where we came from, where we are, and what led up to the Monk decision?
I certainly can. Thank you, Perry. I'd like to briefly canvass the legal developments that led to where we are today. For most of the 20th century, as many of you know, the VA had a unique status among all federal agencies. Its decisions on claims for VA benefits were barred from judicial review by a judicial review preclusion statute passed in 1933. Then, beginning in the 1970s, some circuits recognized a loophole in that law, allowing challenges to VA regulations in district courts. That loophole led to several successful class actions against the VA. For example, in Niemer versus the VA, filed in 1986, a district court certified a class action on behalf of hundreds of thousands of Vietnam veterans and their survivors who were exposed to the toxic chemical Agent Orange while serving in Vietnam. They challenged the VA's Agent Orange compensation regulations, which provided that there's only a connection between Agent Orange and one disease, chloracne, a skin condition. The district court certified a class, invalidated the VA's Agent Orange compensation regulation, voided all decisions on individual claims made under that regulation. The parties then entered into a consent decree, which has resulted in the last 29 years by payment by the VA of over $4 billion in retroactive disability and death benefits. Similarly, Justi Bravo versus the VA was filed by a class of 700 Puerto Rican veterans in district court, challenging the special mass review the VA conducted of all veterans in Puerto Rico who had service-connected disability ratings of 100%, but not of any veterans in any other jurisdiction. And this review was based on a local agency directive that said to be 100%, the veteran had to be in a nearly vegetative state of mind, which differed substantially from the regulations in CFR. The district court approved a settlement agreement that voided all the rating reductions and required that they be re-adjudicated out of Puerto Rico by the Winston-Salem Regional Office. 80% of the veterans won full retroactive benefits back to the date the reduction occurred, and over $30 million in an aggregate amount of benefits. Now, as you mentioned, in 1988, Congress finally repealed the bar to judicial review in the VJRA, the Veterans Judicial Review Act. That act provided two pathways for federal court review of the VA. One, you could file a direct challenge to a VA regulation in the U.S. Court of Appeals for the Federal Circuit. Two, you can appeal an individual decision by the Board of Veterans Appeals denying your claim to benefits to a new Article I court, the U.S. Court of Appeals for Veterans Claims, as you've nicknamed the Veterans Court. With further review from the Veterans Court to the Federal Circuit on a limited basis. The VJRA was silent on class actions under this new regime. Shortly after the court opened its doors, veterans petitioned the VA, petitioned the Veterans Court to adopt class action rules. And the Veterans Court met and rejected that request for three reasons. One, they said we don't have authority to do it, to entertain class action. We can only have jurisdiction to review individual appeals from the Board of Veterans Appeals. Two, there would be difficulties in managing, in the first instance, a class action in an appellate court. Three, it was unnecessary given the availability of precedential decision-making in a national court. That was in 1991. Veterans wandered in the desert for the next 26 years without the ability to file class actions. Then in 2017, out of the blue, came a bombshell, the Federal Circuit's decision in Monk. Monk had used a separate avenue to get jurisdiction in the Veterans Court, a petition for a writ of mandamus under the All Writs Act, which provides that all courts established by Congress may issue writs that are necessary and appropriate in aid of their respective jurisdiction. Monk, a pending VA claimant, sought a writ of mandamus to compel the Board of Veterans Appeals to decide his appeal, which, like hundreds of thousands of other claimants, had been pending for years without a board decision. He sought to represent a class of claimants who had appealed but had been waiting an unreasonable amount of time for a decision by the Board of Veterans Appeals, which Monk defined as over 1 year. A single judge of the Veterans Court summarily denied class certification, citing the Veterans Court's 1991 refusal to adopt class action rules. Monk appealed to the Federal Circuit, which overruled the Veterans Court's long-held position, holding that the Veterans Court has authority to certify and adjudicate class actions under 1, the All Writs Act, 2, other statutory authority, and 3, the court's inherent powers. As to other statutory authority, the Federal Circuit pointed to two things. One, the Veterans Judicial Review Act's Section 7264, giving the Veterans Court express authority to prescribe its own rules of practice and procedure, and the Federal Circuit pointed out that other tribunals had used that same statutory authority to promulgate class action rules. Second, the Federal Circuit cited pre-VJRA class actions like Niemer and Giusti Bravo, and stated there was no persuasive indication that Congress intended to remove class action protection for veterans when it enacted the VJRA. Finally, the Federal Circuit said class actions can help the Veterans Court, promote efficiency, consistency, and fairness, and improve access to legal assistance by parties with limited resources. That's a key part to the Federal Circuit's decision. I keep that quote by my bedside. Consistency by increasing prospects for precedential decisions. The Veterans Court, the Federal Circuit noted, decides over 97% of the appeals that get to chambers by single judges. You all are used to courts of appeals that decide in panels of 3. Not so at the Veterans Court. Most cases that go to chambers are decided by single judges. And the Federal Circuit said perhaps permitting class actions would help prevent the VA from mooting claims scheduled for precedential review, citing examples of cases that were sent by a single judge to a panel of 3. The court scheduled oral argument, and shortly before oral argument, the VA settled the case by giving the individual all the relief he or she wanted and avoiding a precedential decision, which could be against the VA. In addition, citing a law review article written by one of our panelists, Mike Allen, before donning judicial robes, the Federal Circuit said a class action rule would permit the Veterans Court to serve as a lawgiver and error corrector simultaneously and used to compel correction of systemic error and to ensure veterans are treated alike. So that's the Monk decision by the federal court. It then remanded it to the Veterans Court to reconsider class certification. And the ball was then below in the Veterans Court, and I turn it over to you for further discussion by the panel.
Very good. So, right, as you mentioned, after the Federal Circuit's Monk decision, the Veterans Court became had the authority to certify class actions, and it has certified 3 so far. So, Adam, will you give us an idea of, tell us about those 3 cases and what kinds of issues come up when you're dealing with class actions at the appellate level? You're muted.
Sure, I'm happy to. And by the way, thanks for having me. I'm thrilled to be here. So I wanted to bring up, I'll briefly summarize these 3 cases and highlight 3 issues that I think these 3 cases raise. So the first actual case that was certified as a class action was not the Monk litigation. The Monk litigation below split 4-4. It went up on appeal to the Federal Circuit. A panel denied class cert of the Federal Circuit, and I think the parties are still exploring their legal options. But since the Monk decision, there have been 3 cases that have been certified as class actions, and they illustrate the range of issues, as well as the kind of unique authority that this court has in considering class actions. The first is the Godsey v. Wilkie case. That was a class that was certified in 2019. And the Godsey class challenge, it was also a case about persistent delays at the VA. It challenged the VA's persistent delays in transferring appellate records for review. And that's, as I understand it, to be a very ministerial process. But even though it's something that's totally outside the hands of veterans, it really rests in the VA's decision as to when it's going to send those case records for review. On average, it was taking the class members over 1,000 days for the past when the veterans had filed their substantive appeal. So the court certified a class there. It was a delay class action. It found that the VA's practice violated the petitioner's rights to due process. They reasoned that allegations of that kind of systemic delay on behalf of all of them were better addressed in a class action context. Because if they were to just grant individual delay positions, that would result in no more than line jumping without really resolving the underlying problem that gave rise to the delay. And the court found that it could more efficiently and easily monitor compliance with that kind of class-wide order than by requiring unrepresented claimants to file their petitions seriatim. And it was a very effective class action, as I understand it. According to the VA, it was required to report back to the court within 60 days as part of a court order. Within those first 60 to 90 days, it resolved over 1,700 of those cases. All the class members were just simply asking for the cases to receive an adjudication. They weren't asking for a particular outcome, and 1,700 of them were had been resolved. And I think by this time, there was a hang-up with respect to a subset of those class members' claims. But as I understand it from, and maybe Mark can educate me later about whether I'm right about this, I think all the class members' delay claims have now been resolved by this time. The second case, and I always worry that I'm messing up the pronunciation of the class member's name, is Score v. Wilkie. Score involves something that happened in the mid-1960s. Two Air Force planes collide over Palomar, Spain, and the collision dislodges 4 hydrogen bombs. They fall to the earth, they release clouds of radioactive dust over the Spanish countryside, and the Air Force sends about 1,600 airmen to Palomar, Spain to clean up the accident's aftermath. And the Yale Veterans Legal Services Clinic represents a class of veterans that challenged the VA's policy for claiming that they were exposed to radioactive radiation and they suffer a broad range of health defects in the ensuing decades. Oh, did something happen? Oh, I'm hearing some kind of feedback. As the class alleges that that the VAs unlawfully refused to recognize Palomares as a kind of radiation risk activity under the regs, and that they unlawfully relied on a flawed scientific methodology to deny their disability benefit claims under other regs. In trying to determine whether or not to certify the class, the court remanded to the VA to assess how many plaintiffs were actually subject to the VA's methodology and whether it was grounded in sound scientific evidence. Now, remanding to the VA was a departure from the court's practice, but it was a helpful procedure for the court to adopt because that allowed it to rely on the agency to kind of do some of the fact finding that a court would normally have to do in class certification, including how many people were actually subject to and members of the class. The court gave the agency about 90 days to reach that conclusion, and relying on the findings that were produced, I think the VA identified about 1,300 or so veterans. The court was able to find the lead class members' claims were at least typical of the class members, and that the class was sizable enough to warrant class certification. Last but not least, there's the Wolf case. That was a class that was certified in September of 2019. And that class challenged the VA's practice of denying emergency medical coverage to veterans who received partial coverage from another non-VA form of insurance. And it's weird summarizing these cases as I know that there are panelists, co-panelists have actually brought these cases. But as I understand it, there was another case about 3 years earlier called Staub, where the court had rejected the VA's decision to deny this kind of emergency medical coverage. But the class maintained that the VA continued its practice anyway of denying this kind of coverage. The court, in certifying the class, went a step further, observing that the VA was affirmatively informing veterans that they were not entitled to reimbursement for non-VA emergency medical care that the court had ordered previously. And it certified a class, saying it was necessary to certify the class to respond to what it perceived as a systemic error that was frustrating the veterans' rights to a fair adjudication of his claims. I have a quote from the court: "Who knows how many veterans relied on such misrepresentation, but that's what it was in deciding not to appeal their VA decisions that denied reimbursement for non-VA emergency medical care." And the court really saw a class action here as the only realistic answer for unrepresented veterans without the benefit of legal counsel who could help them interpret this old precedent, not that old, 3 years old, given the approach that the VA had taken to that precedent in the past. So we have those 3 cases, and there, I think, are 3 questions that animate those cases and questions that the court, as well as practitioners in front of the court, are going to have to think about moving forward. The first relates to something that's obscured by the name that we've now given this court. By calling it a Veterans Court, we're actually obscuring an important thing. It's called the Court of Appeals for Veterans Claims, and that's a really important fact because normally Court of Appeals are courts of review, not first view. They have limited fact-finding power, and class actions oftentimes might require some knotty factual questions to be resolved. So how does an appellate court resolve those kinds of factual questions? Well, one way the court's done so, like in the SCORE cases, is sometimes remand some of those questions to an agency and let the agency carry some of that water. Another way that the court is considering is the appointment of special masters under the federal rules of appellate procedure. And I think in the last request for funds from Congress, the chief judge of the CAVC asked for funding for a new special master. And there's going to be a persistent question about how much power a federal appellate court like this should give to other officers to decide important factual questions. When appellate courts allow non-Article III officers to review unlawful government action, they arguably give up one of the benefits of having a generalist court review what's going on, which is that there's an independent generalist review of the coordinated branches of government that's binding on all parties. But one of the benefits of remanding in a case like SCORE is it can take advantage of the unique expertise of the agency in determining the science that was used, as well as some of the facts on the ground, and as well as some things that might be uniquely known by the agency, including like how many people are affected by a particular policy. The two other things I'll just quickly note. One is procedural innovation. For at least the past year and a half, the court has been hearing class actions, as Bart noted, under the All Writs Act. There isn't a formal rule to do so. Now, that's not unique. There are other courts that have done that. The Federal Court of Claims heard class actions for over a decade without a formal class action rule. Other parts of that court, another Article I court, the National Vaccine Program, also hears not class actions, but something like it called omnibus proceedings. And the idea of hearing class actions under the All Writs Act isn't new. It's something that's been done in the federal courts for actually over 50 years in habeas cases, in immigration, and in prison cases. But it still raises this question, and one that's frequently raised in complex litigation, which is how much power should courts have to innovate in hearing large, complicated cases. Now, one of the benefits, as it turns out, is that at least in this case, it seems as though being able to experiment for a little while has complemented the rulemaking process. The Veterans Court on the eve of Veterans Day released its class action rules. And as I understand it, as just an impartial observer, there are some ways in which those rules have been informed by those experiments that have been ongoing by hearing cases of the All Writs Act. For example, to my next point, one of the rules that's different from Rule 23 is it asks petitioners filing with the court to explain why a precedential decision wouldn't be better, like why a precedential decision wouldn't be superior to a class action claim. Now, that's not something that's in the federal rules, but it's something that this court has learned is an important question given that it's a federal appellate court. And that leads to my last point. An appellate court hearing class actions. It's the only court to do this in our federal system. I don't know of any other state appellate court that's done something like this. And precedent itself serves some of the same functions as aggregation in our procedural rules. It allows courts to hear common claims and to resolve like claims in a like way. But one of the things that we've at least seen and perhaps learned from observing this court's experiments with using class actions is that there are downsides to precedent. There are some cases where precedent isn't enough in systemic reform litigation. This is something that's actually recognized even in class action practice when courts have adopted a doctrine and trying to decide when an injunction isn't enough, when they actually have to hear a case as a class. And there is a doctrine known as the Necessity Doctrine. And it essentially, courts have essentially held of this doctrine that there are times where a class action is really better, more important, superior than injunctive relief. When cases might be mooted, like they never actually reach the court because the cases are picked off for one reason or another, it would facilitate the enforcement of a judgment, kind of like the last example, the Wolf case that I gave you, where the only way to kind of ensure that a judgment is enforced is by ensuring that there's actually a mechanism like class counsel to make sure people get the benefit of that judgment. And when there's not the same kind of certainty that the government's going to be able to apply its judgment uniformly to all the members of a class. And that's something that's definitely true for like a delay claim. You know, when the concern is that people are falling through the cracks and cases might never actually reach the court because of some type of systemic delay, there might be a concern that absent a class, there might not be a way to ensure that all the people who might benefit from that class are even identified so that the court can kind of provide the relief that it ultimately did provide in a case like God's. And but those are three cases of interest, and I think three questions that these cases raise. Questions of how this court will find facts, questions of procedural innovation, and questions of like what the role of a precedent is in and how it should affect when a court is going to certify a class or not.
Great, thank you. So as you mentioned, Adam, the court didn't right away adopt rules that it was going to follow in these class action situations. It said in the meantime, the Veterans Court said in the meantime, it would follow Rule 23 of the Federal Rules of Civil Procedure, which is what governs civil class actions in civil court. So a little bit different than in the agency context. And the court did fashion its own rules. They were published for public comment in January and just adopted, finalized last week, November 10th, just in time for our panel and for Veterans Day, which worked out nicely. I believe there's a link to the rules in your course materials, and it's also on the court's website if you're interested in taking a look at them. If you're familiar with Rule 23 class actions, you'll see a lot of familiar terms. Numerosity and commonality and typicality are required. There's provision for attorney's fees. But Judge Allen, will you tell us a little bit about the new rules and how they came to be?
Sure, thanks Perry, and thanks to everybody for inviting me. So I want to talk about two things. I want to briefly talk a little bit about the rules and then just sort of tick off some things that judges on the court were thinking about, which really echoes some of what Bart and particularly Professor Zimmerman was saying. So first, yeah, we did adopt the rules formally on Tuesday the 10th, the day before Veterans Day, and under the leadership of Chief Judge Bartley, we tried to get that done by Veterans Day as sort of a symbolic sort of thing. And so we did that. And you're right that if you look at Rule 23 of our Rule 23, you're going to see a lot that looks like Rule 23 in the federal rules. And that makes sense in the sense that we've had a long history under Rule 23. And so we were able to draw on some of that, but we tried to change it to be particular to our own institution. You'll also see that in addition to amending the rule relating to intervention, Rule 15, those were more technical, we actually added a Rule 22. Now, there is a Rule 22 in the federal rules. We didn't model that. Why did we have two? Well, that's because when we originally were putting together this rule, we had a lot of what's in Rule 22 as the beginning of our Rule 23. But the problem with that is then our Rule 23A didn't have anything to do with Rule 23A in the Federal Rules of Civil Procedure. So we decided, we'll make a separate rule. So Rule 22 has a lot about what needs to be in the request for class certification. And as Professor Zimmerman was saying, one of the things that we highlight that I'll return to in a moment is you got to tell us why you think we need to do a class action versus a precedential opinion, right? Because that turns out to be a really important point for us as an appellate court. And the other thing in Rule 22 I want to highlight is the emphasis we have there in a rule for public notice of class actions that are pending. In fact, we actually say they're going to be on our websites. because we think that's very important because it's new in this area. And then in Rule 23, it does largely mirror Rule 23 of the Federal Rules of Civil Procedure. Although it focuses, you'll see, on what in the federal rules would be the B2 class, the injunctive class, because that's the kind of classes we are going to be handling. And so the only other thing I'd like to say on that is that, you know, there are some aspects, as you all know, of class action process that are dictated by the Constitution, for example. And so we wouldn't have any choice in that. And what I mean by that is, for example, adequacy of representation. Even if a rule didn't say a class representative had to be adequate, they couldn't be bound to a judgment without that adequacy under the Due Process Clause. But we elected through this rulemaking process to decide to essentially adopt a lot of the procedural prerequisites that are in the rule. And so we'll see how that develops over time, and I'll come back to that. But I want to turn to sort of this from the court's perspective, the judge's perspective on this innovation over the last 3 years or so. And I just want to tick off sort of 6 separate points that we've talked about. The first, as Bart was saying, the Federal Circuit in its Monk decision looked at our court's en banc decision in the case he was referring to, I think was Harrison, but from early in the 1990s, that said there are 3 reasons why we won't do class actions. We don't have the authority to, number 1. Number 2, manageability concerns as an appellate court. And number 3, we don't need to because we can issue precedential decisions. You can think of what the Federal Circuit did in its Monk decision in 2017 as essentially taking the first one off the table. It said you do have authority to do it. Then it comes back to us. You know, that at that point, the court made a decision. It was a decision now that's in published decision, so it's not like I'm saying something that's behind the scenes. We had discretion to engage in class actions. The Federal Circuit didn't mandate that we did it. Now, maybe had we said no, the Federal Circuit could have said, well, hey, you didn't get the hint, right? But that was our first major decision, right? Which was, do we do this at all? Which of course implicates so much of what you've heard before, right? We haven't had class actions, we're an appellate court, and all of those things. But we did make the decision for the first time in Monk, although we had to do it twice, as I'll explain, that we would use that authority to engage in class action activities. The second thing we had to wrestle with was, well, do we do it only in a situation like Monk? And what I mean by that is something where the thing before us is not an individual appeal of a board decision, but something under the All Writs Act. Is there a difference of magnitude between those two types of things that we would say we'll engage in class actions in one concept or in one procedural avenue, but not the other? And so the court decided to take 2 cases en banc, Monk, which was a petition under the All Writs Act, and Score, which was a direct appeal of a board decision. In each, there were requests for class certification, and we took both to make the decision about whether we would utilize class actions in only one context or the other. And of course, the en banc court in Monk, while denying class certification in that case by an equally divided vote, said yes, in an appropriate case we will. And in Score, the court actually said by a majority, yes, we will, in that context. The merits in Score have not been resolved. The case, we heard oral argument in early September, and so the merits decision is waiting on that. So we now knew, okay, we'll exercise our discretion to do it. We can do it in both appeals and petitions. And then we face the question that Professor Zimmerman hit right at the end, which is, well, how the heck do we do this? Because we don't have a rule. And the rule of civil procedure number 1, rule 1, says it applies to district courts. So it doesn't apply to us. So we looked and we said, well, what have other courts done? And well, the Court of Federal Claims. They're not a district court either. By the way, neither is the Court of International Trade, which is an Article 3 court, but isn't governed by this. So it's not an Article 1, Article 3 sort of thing going on here. And so we decided to take sort of a dual track approach. We started the rulemaking process, but we didn't stop adjudicating class actions. Now, I think from my mind, we did that mainly, I did it mainly for practical reasons. I didn't want to keep people who were trying to have a class waiting for us to do rules, and I didn't want to rush the rule process just to be done to adjudicate them. So I thought that was a good balance. But I actually think it turned out to be good for another reason, which is, as Professor Zimmerman said, handling class actions, seeing them, literally, like if you think about like molding something in clay, getting your hands dirty, really helped us in thinking about some of the things in the rules. Maybe places where we wanted to be more specific in the rules than we might have otherwise been, but also the reverse. Maybe places where we didn't want to be super specific, we wanted to keep it general because we saw we needed to have flexibility, right? So we went on that dual track process for about 2.5 years. And then in the same time, we were using that knowledge to inform the rules. And of course, we'll see how the rules come out. Professor Zimmerman also mentioned this. There are a lot of challenges being an appellate court and trying to manage class actions. First of all, just think about this. Just basic case management for anybody who's appeared in a district court. Trust me, I heard oral argument in the Wolf case twice. The second time to deal with procedural motions with 3 of us on the bench. We all got along really well, but having 3 people try to do essentially case management, that's actually really hard and not particularly efficient, right? And we don't have any place to look to, right? Because we're not to quote Winnie the Pooh, but from when my kids were younger, we're like Tigger, we're the only one. And so we're sort of feeling our way. What do we do with facts? As I like to tell people, our court in Washington doesn't have a jury box. It doesn't have a witness stand. Right? It's an appellate courtroom, which I haven't seen in a year, but hopefully that can change. And so we got to figure out what to do that. And we're also, we're sort of struggling with that. What can we do? Last 2 points briefly, because I'm just over 10 minutes. This point about how do we distinguish between having a precedential opinion and a class action is super important. In my context, and I've said this in published decisions, even more so in the context of an appeal for various reasons. But because if you think about it, the danger is you slip to, well, then everything should be a class action, or nothing should be, because if a precedential decision binds everybody anyways, what does the class add and how do you distinguish? And that's something I think we're going to be feeling our way in for a while. And the final point that we've been struggling with, and I think the Federal Circuit will have to struggle with this eventually, are a whole bunch of jurisdictional issues. What do we do when we have a limited remand to the board? Does that change the jurisdictional landscape? What do we do with the fact that this prohibition on finding facts is jurisdictional? Because the statute uses a weird phrase that says we can't have a trial de novo. What happens when we make a class certification decision and somebody wants to appeal just that to the Federal Circuit? Because the federal rules of civil procedure don't apply. And we can't insert into our rule that, oh, go ahead, appeal to the Federal Circuit, because we can't tell them what to do. And then, of course, what does the Federal Circuit do in deciding how they exercise appellate authority over class certification decisions? Because technically their jurisdiction doesn't extend to the application of law to fact. But of course, deciding whether to certify a class is all about the application of law to fact. So that's just some of the issues that we've dealt with at the court in this sort of adventure that we're all starting on our own here.
It's so simple. Just do class actions. You'll figure it out as you go along, right? So Mary, I want to turn to you. Could you tell us what types of class actions the VA is seeing and how you're handling them, what your position has been on them?
Sure. So in addition to the 3 big ones that have already been discussed, we've seen 10 other cases where either an appellant or a petitioner have moved for class action or aggregate action. So I thought I'd kind of quickly go through them. So just one day after the Federal Circuit issued its decision in Monk, we had a writ petition that had been filed a few days earlier. And so on April 27th, the very next day, they filed a motion for aggregate action. So that was the Rosinski case. Now, there are several Rosinski cases. This one dealt with entitlement to see a draft rating decision by accredited attorneys. So Mr. Rosinski filed his writ. That was the issue. And his proposed class was all VA accredited attorneys designated as a representative record on a valid VA Form 2122A. So that was his proposed class, pretty broad. The case was briefed, and as has been mentioned, one of the challenges is that these have sort of been handled very differently in terms of, is it just the class part that needs to be addressed? Do we address the merits? Does one come first? And they've been handled differently in different cases. So this one, we were ordered to respond to the writ. Then we were told we also needed to respond to the class, to the aggregate action. Briefs were filed, the oral argument was held, and in the end, in January of 2018, the petition was dismissed by the court. They found that Mr. Rosinski lacked standing to challenge VA's policy, and that absent having a claim for which he had standing and could serve as a class rep, that the court found no basis to grant aggregate relief. So that was the first one. He also filed another motion for aggregate action in another Rosinski case. This one was an appeal. And this is the case that you may be familiar with that addressed entitlement to attorney fees for past due benefits when there was a military retirement pay at issue. So this case started out as a regular appeal. The notice of appeal was filed to in September of 2017 to a September board decision that had denied entitlement to attorney fees from past due benefits. And then shortly thereafter, he filed a motion for aggregate action. And the proposed class there was all accredited attorneys with contingent direct pay fee agreements who received attorney fees based on fee determinations dated on or after June 8th of 2007. That was the date that the Snyder opinion was issued. So that case as well started to get developed. It was submitted to a panel, it was briefed, and then in May, the end of May of 2018, the appellant moved to withdraw his motion for aggregate action. So that part of the case just went away. And the case went on, the court went on in a precedential opinion in January of 19, or excuse me, just this past year, the court issued a panel decision reversing the VA's opinion on the merits. But the aggregate action part was never addressed by the court. The next one that came along was a consolidated appeal of Neal and Ward. This involved a challenge to VA's a requirement or an interpretation of the need for a permanent worsening standard for deciding whether a service-connected disability aggravated a secondary disability. So both appellants, Ward and Neal, filed independent notice of appeal to separate BVA decisions. And then after their briefs had been filed, they filed a motion for class action and then a motion to consolidate. So again, we have sort of a mixture of this one, the briefing was done, and then the class action part sort of got layered on top of it. That also, of course, went to a panel. It was stayed for a while. It was then submitted to the en banc court, and then the en banc panel was dissolved. And then in June of 2019, the court issued a precedent where they invalidated the VA's requirement for permanent worsening, but they denied class action. And they said that because this is a precedential opinion, which should have full effect throughout VA, the court will deny the class certification motion at this time. And it directed VA to take steps to immediately implement this precedential decision. Judge Greenberg dissented, and he indicated he would have certified the class. Simon was another appeal. That was a Blue Water Navy case, and the proposed class was certain Navy veterans who served on ships in the waters of Da Nang Harbor and were exposed and have one of the listed presumptive diseases. This case sort of got overtaken by events because it was stayed pending Monk, Overton, and Score. And then while it was stayed, Procopio and the Blue Water Navy legislation was passed. So the court asked the appellant, do these developments change your position at all? And the appellant advised that they were moving to withdraw the class action motion. So the court lifted the stay, directed briefing to resume, and in light of the legislation and Procopio, the parties settled that individual appeal. Johnson was another appeal. This one was, the notice of appeal was filed in December of 2018, and then in April of 2019, they filed a motion for aggregate action, a motion to stay pending a ruling on that, and they also sought injunctive relief for the secretary. This case involved entitlement to service connection for hypertension based on exposure to herbicide exposure, the Agent Orange Act. And at issue was the National Academy of Sciences updates and whether that was constructively before the secretary so that VA should have offered a disability exam to the appellant. So that was another one that got fully briefed on both issues, or both the class part of it as well as the merits. And then in August of 2019, the appellant moved to withdraw their motion for aggregate action. The panel was dissolved and the case was ultimately decided by a single judge, and it was a remand. Bowling and Appling are two other, it's another consolidated appeal. This case is still pending. And the issue is they want to certify a class of persons who have been or could yet be denied benefits based on VA's definition of insanity as set forth in 38 CFR 3.354A. The cases were started out separately and then they moved to consolidate. They went to a panel and the case was argued before a panel in June of this summer before judges Bartley, Meredith, and Falvey. Mancusi was another appeal. This was a complaint about mailing, mismailings. And so the proposed class was all claimants whose appeals were denied as untimely after various ROs failed to mail decision notices to their private attorneys between when the attorneys received access to VBMS, the electronic claims process, and March 23rd, 2018. So they were, that was kind of an unusual one because it was hard to figure out how you would ever identify that group. But in looking at the particular, the only named claimant in that appeal, there was an obvious defect for another reason. And so that case was settled. Gardner-Dixon was recently decided. That was a writ. And that case involved a remand, a board remand, and the petitioner thought that the remand was unnecessary, and so his writ sought to contest the remand and also to have the court certify a class composed of all claimants who have received or will receive a board remand decision in whole or in part, not in accordance with law. That was denied twice by Judge Greenberg. Then it eventually went to a panel, and the panel decided to hear argument after the petitioner filed a motion for class certification. So then that issue got addressed. The petition was denied just last month. The court found that the writ was not in aid of its jurisdiction because it involved a board remand and it was not a final BVA decision. But the court did also note in a footnote that even if it was inclined to address the class action aspect, that class actions should be the exception, not the rule, quoting SCORE, and that the petitioner's motion provided only a single sentence addressing each of the Rule 23A requirements. Judge Greenberg dissented in that case as well, and he indicated he would have granted the writ, but he didn't mention the class action aspect. And then we have two fairly recent ones that have been filed. Bodette, this is a VHA case, and it involves the Caregivers Act. So this is a writ petition where the petitioners are seeking to be able to appeal denials of benefits under the caregivers program to the board. Currently, it's limited to only a VHA process. So their proposed class is all individuals who received an adverse decision relating to benefits under the caregiver program, exhausted the available administrative review process within VHA, and were not subsequently awarded the right to appeal to the board. That case is still in its fairly early stages. VA was ordered to respond to the petition, and we did that. And they allowed the petitioners to refile and address their class action. The court didn't think it was developed enough, so it ordered them to respond, provided them an opportunity to beef that up, which they did. And now VA's response to that, the class action part, is due December 7th. And then the last one was just filed. This one involves hearings under the Appeals Modernization Act. The proposed, and this is an appeal, they appealed a May 2020 BVA decision that dismissed a request for a hearing at the agency of original jurisdiction. So the class being sought is all claimants for VA benefits under the AMA who requested a hearing at the AOJ during the pendency of a supplemental claim and have been denied or will be denied the requested hearing, plus all claimants who have been denied the right to appeal the denial of an AOJ hearing. That case, the class action part, was just recently filed, and just today the court ordered the appellant to refile to comply with the new rules. So that one is at its very early stage. So that's sort of what we've seen. It's a wide range of types of classes, and also the way they've been handled and developed, and outcomes.
Thanks, Mary. We've got some questions coming in from the audience. I'll kind of throw these out to the panelists unless they're clearly directed to one of you. Somebody asked if there's a way to opt out of a class like there is under Rule 23. I see some nodding heads.
Well, I can say that so Rule 23 itself, the Federal Rule of Civil Procedure 23.
I should clarify.
Yeah, it's a lot of words. That doesn't allow opt-out as an automatic point for B1 and B2 classes. the court can allow opt-outs in those contexts, but they just don't make particular sense in that context. And so our rules don't follow the federal rules, and we don't have as an automatic basis opt-outs. And our decision in SCORE in particular, we mentioned this a little bit in Godzi, but our decision in SCORE goes a little bit more in depth about why it is that having to determine that a class is appropriate, that opt-outs are not the appropriate course. And the Supreme Court seems to have indicated that opt-outs are required for B3, but not for B2 and B1 classes.
Right, so just to put that into layman's terms a little bit, so B3 class actions are where classes are seeking money damages, and everything that's coming out of your court is going to be injunctive relief, right?
It's going to be the functional equivalent of what would be an injunction, yeah.
Thank you. Adam, did you want to chime in?
That's exactly what I was going to say. The rules are structured to not allow opt-outs in particular types of cases where the relief is essentially binding on the government as to all, which is why we typically don't allow opt-outs in those types of cases. There are other types of courts and that have adopted rules that are just for injunctive relief class actions only, and they do the same thing. They also don't allow for opting out. Like the EEOC, for example, has a class action rule itself. It's based on injunctive relief class actions, and so it also doesn't have a provision for opting out for exactly the same.
Let me add a point. That's because there's no opt-out procedure. That is why the part of the new rules that Judge Allen talked about that involve the clerk of the court putting up information on the court's website about all the class actions that are filed, that allows people who perhaps represent somebody who'd be a member of the putative class or otherwise have an interest in the outcome can intervene formally or file an amicus brief or talk to counsel for the putative class and try to influence the way the case turns out. And I think that's a very good development for a court that's not going to generally allow opt-outs.
Judge Allen, I've got a question that's directed to you saying that, so now you have some experience with granting and denying class certification. Can you give us a general sense of what kinds of class requests the court is most likely to embrace? And he says, more importantly, which might be most beneficial to veterans?
Only at an exceedingly high level of generality, right? And so, you know, first of all, I do think that people need to take very seriously the rules that have come out that suggest that the choice about going to a class action is one that needs to be not one that a party makes in a perfunctory way, as Mary was saying. You know, we have seen motions that are, you know, 1 or 2 sentences long, right? This is a major effort. And the focus is on why it is the class is so important, given that we could issue a precedential decision, right? So that being said, I think that Professor Zimmerman hit on something that you see in the cases that we've talked about already, either declining to certify a class or granting certification of a class. And that's this idea that there is a systemic issue, right? And so if you think about delay claims and things that are close to delay, I mean, we have said this in Monk, the Federal Circuit, in a case called Ebanks or Eubanks, I don't know how you pronounce it, it's spelled Ebanks, said this as well, not in a class context, but that one of the problems with the writ device when you're dealing with a delay for one person is if we order VA to say, do it for this person, the danger is that person may then jump in front of tons of other people to get the relief, even though those other people also deserve the relief for the same reason, they just didn't file a writ. And so things that fall into categories like that I think are going to be the most likely type of candidates you're going to see from my perspective. I think there could be other situations where, as we noted in SCORE, particular needs for enforcement or management of a decree, as opposed to simply saying the law means X, now just go apply the law, which is what an appellate court does all the time, right? So I think those are the kind of things that are most likely. But I think we're gonna, as Mary was saying, the types of things that we're being asked to consider for class actions are really quite broad. And I think, we're just gonna have to take each at a time, I think.
You mentioned how much more work this is making for the court. So somebody asked if you have plans to hire more attorneys and other help to.
Well, so we do have funding in our budget. I know the Chief Judge has said this at some events, to if we wanted to hire special masters to assist us in whatever we would use a special master for. So that's the possibility. I know the Chief Judge has also spoken about the fact that the court has increased staff that is not directly related to class actions. It's related to the fact that, about 4 years ago, we had about 4,300 appeals, and this year we're just under 9,000. So that volume of things is really particularly hitting the court's central legal staff and public office, not so much the judges' chambers, because a lot of these are getting resolved at the mediation conferences. But I know that's on our end. I do feel for the VA and Mary in particular, because for us, the mere fact that you look at the total number of appeals that go up doesn't mean that a judge is getting more appeals. Maybe it does, maybe it doesn't, but it doesn't correlate one-to-one. But I can guarantee you for the VA, it correlates one-to-one. If you go from 4,500 to 9,000, that is a real number. It's not like you subtract any. And so that's where we're seeing staffing. It's not yet with class actions.
So Mary, do you have any plans at the VA to staff up to help out here?
I wish. So, we, like Judge Allen said, we're just been crushed by the output from the board. So we've been trying to keep pace with that. And then having the class action litigation kind of coincide with that has been a double whammy. Because what we've been learning about these cases is they're so complex, and they add a whole other layer to litigation. And we're all learning this. So we're trying to get up to speed. We try to have, it seems to be working when we can, to have 2 people on a class action case. So we'll have one person who can try to focus on the class action part and the other person focus on the merits, if we're able to do that. But right now, unfortunately, we're under a continuing resolution. So we don't have a budget, and who knows when we will get one, but it's also a 2-year budget cycle. So, we have mentioned in our budget requests that, the class actions add a whole other level, and have tried to, have sought additional people, but whether we get them, too soon to tell, and we probably won't see them for quite some time.
Right. So Bart, as someone who's bringing these on the ground, somebody has asked what advocates should think about when they're bringing veterans court class actions. What should they keep in mind?
Well, I think the most important thing is to focus on a key ingredient, a key part of the rule, is that you have to show that the VA has acted or failed to act on grounds that apply generally to the class, so that final injunctive or other appropriate relief is appropriate respective of the class as a whole. Now, I've talked to a number of advocates who tell me that they've seen repeated VA denials based on the same reasoning. And they want to file a class action so that doesn't continue to happen, but that's going to be difficult to base a class action on common grounds when you've seen it in your individual cases and you don't have a real way of showing that the VA does that to a great extent for a whole group of people that you can define. So it's much more important, if you can, to focus on a written policy of the VA, either in a regulation or a manual 21-1 provision, or as in the Giusti Bravo case, a directive issued by a regional office that can show what the practice of the agency is. Cases like, I think Mary mentioned, the latest class action filed focused on the reluctance of the regional offices under the AMA to grant a hearing, which I know they don't want to do. They don't advertise that you can get a hearing before the regional office, and the lead class representative was told, no, you can't have a hearing. But the problem they're going to have is to show that that's a systemic problem, that the VA's refusing to grant a hearing to many people who were asking for hearings as a policy. And so that'll be the difficulty for those people. I'm not saying it can't be done. If they can show certain regional offices do that all the time, but you could see the proof difficulties in that sort of case. So that's the type of issues I think advocates should focus on.
We are running up on time, and I want to give everybody a chance to give their final thoughts. So I'll ask each of you, have you got anything else you'd like to mention, or something that you'd like to emphasize? And I'll start with you, Judge Allen.
Well, I just want to thank NVLSP for having this. You know, if you think that anybody who's on this call that you're seeing has all the answers about how this is going to work, you know, you're sorely mistaken. And that's really because I think what people have to understand when you're going through this, and what I would urge people to think about, is that and frankly, I say this to my law clerks when we're talking about these cases, because they'll come back to me and they'll say, I can't find an answer to this question. And what I tell them is, well, of course you're not going to find an answer to the question, because nobody's ever asked this particular question in this particular context before. Right? And so one of the things that I want to really leave everybody with a thought of is that this is an ongoing experiment of taking a rule designed for a trial court that cannot by its very nature bind anybody but the parties before it without the class device, and then use a device in a forum that is not a trial court, so doesn't have the things that trial courts can do, but yet has a power that trial courts don't, which is we can bind everybody that's relevant to us at one time. Those things can go together. They're not like AC/DC current or something, right? But it does take some cooperation to think about how it is that we take a concept that arose in an entirely different area and then plug it in. And I would say, you know, for scholars like Adam, you know, I think this does provide fertile ground, because it is a way to see an experiment in a procedural tool that in the district courts is often tainted by something that won't be here, which is money. Right? This is not going to ever be like, oh my goodness, it's, you know, $1 million award to the lawyers and $1 to a veteran. No, because that's not the kind of classes we're doing. So it really gives that opportunity, I think.
Mary, how about you? Final thoughts?
Sure. I mean, like everyone has said, it's kind of a whole new world, and we're trying to figure this out as we go along. I know that there's sort of a concern that VA is just reflexively opposed to class actions. And I don't think that's true. It's really, and maybe it's my own lack of imagination, but I think it's hard to figure out how it works in this context, where the system is really designed at its core. It involves a particularized individual review of the veteran's case. And so even if you have an invalidation of a rule or regulation or something like that, how it applies still requires an adjudicator to open up the file and figure it out how it affects this particular veteran. And so I have trouble figuring out some of the where the efficiencies are if, you know, we're just forcing a big group that still has to be, you know, kind of the pig in the python. So we're just changing it, but somebody still has to evaluate the case. And so if there was, you know, if there is a way that VA can dispose of a big group of claims really efficiently, we're all over that. It's just, I don't know, we haven't seen it quite yet. And but maybe, you know, maybe it'll still happen.
Right. How about you, Bart?
Yeah, well, to respond to what Mary had to say, you take the Wolf case. The Wolf case was a challenge to a VA regulation that prohibited the VA from reimbursing veterans for coinsurance and deductibles. The position the VA took is that every single veteran had to exhaust the agency system and then appeal to the court from a Board of Veterans Appeals denial. And in every case, the board would have to deny the appeal because they're bound by the regulation before the court could consider this case, and that's why it shouldn't be a class action. I would think the VA would want to get a resolution of the issue whether the regulation was valid or not, and therefore it wouldn't have to do all these adjudications. And the relief the court granted was to strike down the regulation. And yes, in each and every case, the VA has to re-adjudicate the case, applying the law to the facts of the case, which was always true, but not under the guise of an illegal reg that prevented the agency from granting benefits when it should.
And Adam, what about you?
I have three final thoughts. The first is that even though government class actions aren't the class actions that we often see in the headlines because they're not money-making class actions, the government class actions are the basis for the modern class action rule, that when Rule 23 was revised over 70 years ago, it was revised in part because of the unique problems facing litigants in the wake of Brown v. Board to try to desegregate schools. And the problems that they faced were the fact that it was oftentimes difficult to ensure that large groups of unrepresented people facing the same types of governmental institutions got the relief that the court ordered. So it's not crazy to have class actions when challenging systemic governmental issues. It's in fact one of the main impetuses and drivers for the way that the rules work today. Point two is that this is the unique challenges that face veterans in trying to bring these types of systemic claims before an appellate court isn't unique to veterans. We have over 200 statutes that channel review of agency decisions into an appellate court, not a district court, which typically lacks the traditional tools to hear class actions. These range from immigration cases to coal mining benefit cases to cases involving federal workers' compensation and people who are challenging Department of Labor regulations. All of them are facing the exact same types of issues when they go to an appellate court that has the ability to hear and resolve a precedential issue, but maybe not have the ability to certify a class. And what are the concerns that really distinguish a precedential type of case from the case that really demands a class action? They're really the cases where people can't get access to counsel to ensure that the agency is going to be able to ensure the court's going to be able to hear their claims, that the agency is going to be able to find those claims to ensure that they can comply. And so traditional types of cases might be group delay claims, like cases like the Godsey case, cases where there's a systemic procedural defect that deprives the appellate court or the agency of being able to find, identify, or process those cases, or cases where you just don't get the informational benefits of a class. You just can't identify who all of them are, what the problem is, and provide them the expert relief that they seek. And so I think as this court begins to kind of grapple with this question, like, when is precedent going to be enough? It's gonna, I mean, one of the things that it might be able to take a lesson from is from the government litigation that's existed with respect to other governmental agencies of the past, as courts have tried to grapple with when a precedent is enough in the Social Security context and immigration context and things like that.
Well, great. There's clearly a lot more that we could talk about, but unfortunately that's all the time we've got. I'm sorry we didn't get to everybody's questions, but thank you to the audience for joining us and for being so engaged. And thank you to our panelists for their time and insights. Everybody enjoy the rest of your day.